Hello, guys. How's it going? I have an update that I want to work on today, and I've got some audio that I need to transfer from a uncopyable source other than doing some sort of a live stream. So I decided while I'm doing this, I'll go ahead and do a live show and let people see what I've been working on for the last year. Partly, been working on several cases, and the case of Daniel Madsen is one of them, and it has gone through some hearings, and the court trial will be coming up December 3rd. So before we get going on the new information, I know many people, you might not know exactly which case I'm talking about here, or maybe just need to be reminded of the specifics of this case before we get into some of the new information and stuff that we're going over. So, gonna play that part of that video first, and then we'll go into more discussion here. So here, let me switch the view. And here we go.
Daniel Madsen.
Unlock the car door.
No.
You're not going anywhere until we talk to you further, so...
Am I being detained?
At this point, yeah, you're being detained.
For what? Am I suspected of having committed a crime?
Put your clothes on if you're not dressed, and unlock the door. If you do not follow the instructions, you will be arrested. At this point, you will not be.
This is my passport right here. Here. Where are my pants?
Yeah.
I just showed you my ID. I just showed you my passport. Daniel
Down the
Madsen.
window.
Daniel Madsen, January 6, 1984. This is my passport. I'm looking for my driver's license too, if you'd like to see that as well.
Listen to me. If I ask you more than one more time, when we get you out of the car, and we will, you're going to be arrested if you don't open the door.
Well, I shall certainly not resist arrest if you arrest me.
If you what?
I shall certainly not resist arrest because that would be a crime, and
You go that far.
I'm not committing a crime.
Credentials and have you open the door.
I just showed you my passport. Right here, look.
This is the last time I'm not the door.
Daniel Madsen, January 6, 1984, see?
Unlock the door. Passport's not a driver's license, sir.
Okay, like I said, let me find my driver's license. It's in my pocket. Here, my driver's license.
What's that? Unlock the door at this point.
Here.
Unlock the door.
See my driver's license?
You're not going anywhere.
Am I suspected of having committed a crime?
For about the 15th time, I'm asking you politely, please unlock the door.
it right there so he could see it if he needs to see it.
What are you doing here outside?
Sleeping.
I don't have one. Yeah, Chris. Why is it you won't open the door? Yeah, I believe so.
Hello,
You
sir.
understand me?
Yes.
That's not good enough by law.
That's my driver's license.
It's not good enough by law.
Well, that's my driver's license.
So,
Right here.
you gonna come out of the car? You gonna put the window down?
No.
What's that?
No.
And why not, Daniel?
What crime am I suspected of having committed?
Well, the problem is you're at a place where they call for a suspicious vehicle, and you're not supposed to be on this property unless you have reason to be here. It's a state agency here.
Am I free to go?
No, because we're here doing an investigation right now.
Okay.
You a sovereign citizen?
I don't know what that means.
You don't know? Do you believe in government?
Do I believe in government?
Yes.
Because government's very real.
Okay. Well, Daniel, you gonna open the put the window down or open the door for us? Because by law and by order of the prosecutor's office, I do not have to talk through glass. So I'm gonna ask you one more time. You can put the window down, or your window's gonna be broken.
Well, you will do whatever you want. I certainly will not resist.
You will not?
No.
Good. You're under arrest then.
Okay, so that was the original video. And part of the reason why I am doing this is because I always hate it when these videos come and nobody explains the situation, nobody tells you, what happened afterwards or gives all the details behind what happened. What was the whole situation going on here? So let me fill you in, and then I've got a couple other audios, some evidence that I've gotten from my public records requests, and working with Daniel Madsen through his attorney to get some of the stuff. Okay. Daniel was at the time homeless. He was from Michigan. As you saw, he had a Michigan driver's license. He had Michigan license plates. His car was registered. His car was insured. His driver's license was valid. He was moving to New Jersey, and he didn't have a place to live yet. And so he was living in his car. Okay. He had a mattress back there, blankets. He had curtains in the back of the van. This was a Dodge Caravan that he was in. Okay. So he needed to go to the DMV. So in the middle of the night, he had come to the DMV area where the DMV was. And living in your car, you got to look for a safe place to go and sleep, right? Middle of the night. He got there, according to him, he got there about 3 o'clock in the morning. Okay. So across from the DMV was a little strip mall. Okay. It had a Dollar General in it, a dollar store, and a couple other little stores. Okay. So, it's dark. There's no signs saying, no trespassing, no loitering, no overnight parking, private parking, anything, nothing. Okay. So this was a quasi public parking lot. Okay. So he goes in there, parks over to the side, because he doesn't want to be like right out in the middle. Okay, so he kind of goes over to the left side and parks there. And here I'll kind of show you here real quick where he was parking, because it makes a little bit of difference as far as the police go. And okay, here it comes. Okay, so here is the parking area. Okay, there's the Dollar Tree. There's another store right here, another store right here. Now, he was parked way over here in this back kind of side area over here. He could have picked here because the DMV was right over here, kind of kitty corner across the street. He could have parked way over here, but over here on this side, there were some other vehicles and stuff like that. And for people living in their cars, a lot of times it's safer to park amongst other vehicles, okay? Because if you just park alone, a lot of times the cops come and hassle you. So if you're amongst other cars, you're kind of in a group, no big deal. So he was parked over here, and what he didn't know was that this part of the building right here, was leased out to a state agency. It was called, previously it was called the DYFS, Division of Youth and Family Services. And they had changed it to DPP&S or something like that. Again, it's still family services type thing, okay? So apparently they come in around 6:30 in the morning, some of them, and somebody had noticed him sleeping in his car in the back of the van. And I guess they didn't say anything until later on. I guess probably the person got on break around 10 o'clock, and they probably went outside for a cigarette and noticed that he was still there sleeping in his car. Now, this was I believe it was March of last year, March of 2018. So it was winter, it was cold. So he had his car running so that he could run the heater and stay warm. Now, the security guard, there's a little bit of a discrepancy here. The security guard claims that he came out there before this video started and knocked on the window and asked the guy what he was doing there. And he said he was sleeping. And he says, well, what are you doing at the DPP&S? And he's like, the what? And the guy says, the DYFS. And he realized, oh, that's the family services. And he just kind of laughed like, like he had nothing to do with that. So, so the security guard went back and he called the police. Police came about, I guess, 20 minutes later. And the cop came up and tried to open up his door. Of course, his door was locked. And then he banged on it and said, something like, open up that door, get out of here. Was really angry, according to Daniel Madsen, which really shocked him. So that's when he picked up his camera and he started recording. All right. So then we see all that. A lot of that audio from the cops on the outside wasn't exactly, you weren't really able to hear it. So I was able to obtain another audio, and we're going to play that. This is from the supervisor who showed up at the end and said, he's the one that broke the window. Okay. Here, I'm also going to show you some other views of this property while this is playing, so you can see that there's no signs.
Keep showing a passport, and he did at one point have his driver's license up to the window.
That's okay.
He was also Bud.
Everyone's on, right?
I'm not on.
Okay. Well, someone's on, right? All right.
Yeah, I don't even know if mine's working because of the camera.
Can you see if he's on? I think of where my window punch is. You got a punch? What's that? Well, they give him warnings for the prosecutor's office. He was naked?
Yeah, he was apparently in the back seat.
Yeah. Can you understand me?
Yes.
That's not good enough by law.
That's my driver's license.
It's not good enough by law.
My driver's license.
So,
I've never used it before. I think you just put it on the window.
yeah. You gonna come out of the car? You gonna put the window down?
No.
What's that? And why not, Daniel?
What crime am I suspected of having committed?
Well, the problem is you're at a place where they call for a suspicious vehicle, and you're not supposed to be on this property unless you have reason to be here. It's a state agency here.
Am I free to go?
No, because we're here doing an investigation right now.
Okay.
You a sovereign citizen?
I don't know what that means.
You don't know? Do you believe in government?
I believe in government.
Yes.
The government's very real.
Okay.
I don't know how this thing works. Put it on the glass and push it. No, just put it on the glass.
Yeah. All right. Well, Daniel, you gonna open the put the window down or open the door for us? Because by law and by order of the prosecutor's office, I do not have to talk through glass. So I'm gonna ask you one more time. You can put the window down, or your window's gonna be broken.
Well, whatever you want. I certainly will not resist.
You will not?
No.
Okay. You're under arrest then.
Out of the car.
Out of the car. Come on.
Go to the car.
What did I do?
Obstructing an investigation to start with.
Not playing with you.
I got it.
Good.
Hear that? Obstructing an investigation to start with.
Call for a record because we gotta get all this cleaned up.
All right, so that audio goes on for another 19 minutes, so I'm not going to bore you with the whole thing. They go through, they do a search, they look through his stuff, they try to find anything to get this guy for. I mean, he's got to have something, right? he's got to have drugs in there, or he's got to have something illegal. There must be some reason why he just doesn't do exactly what we tell him to do, right? I mean, it's just, normal people do whatever the police ask them to do, right? So it raises my suspicions when somebody doesn't automatically jump when we say jump. God damn it, that's just not right. So, I mean, okay. Now, first of all, take a look at this picture again. You can very clearly on the right-hand side there see Dollar Tree, right? Big giant sign, Dollar Tree. Okay? But then look over to the left and there's a sign for the Department of Family Services. You can't really make out. It's small. It's not huge, I mean, they're not really trying to advertise. They're not a store trying to bring in customers. As family services, as you know, they go and get their own customers by going and stealing people's children. So, basically, there was a lot of things. Yeah, you're right. Having by order of the prosecutor, they don't have to talk through glass. See, that's bullshit. Okay. He said that that's not good enough. Now we're going to hear the court hearing here in a little bit, and they're going to talk about a bunch of this stuff. Okay. And what they're going to try to claim is that this guy parked way over here. Okay, he was in this next to the last row, right over here, probably back around where this kind of silver van back here is, approximately in this area. Okay, they're going to say that he had a vantage point of looking and being able to see this side door right over here that the employees use. And at the same time, he could watch he couldn't see the front door, they said, but he could see anybody approaching the front door. So they're going to say, we've had people, we've received death threats at Family Services, and we've had people come to attack employees and stuff like that, which I can certainly believe that. Okay, I mean, when you're talking about Department of Family Services, where they go and they take people's children away, sometimes for little or no cause, I could see how people could certainly get upset. Okay, when you're messing with somebody's children, that's a touchy subject. Okay, so, but now you got to remember, reasonable suspicion must be particularized, okay? It means it has to be particular to him. Supreme Court has ruled, other courts have ruled, that simply being in, quote, a high crime area is not enough. So simply being in this parking lot where people could be there that have made threats against Family Services, that's not particularized suspicion on him. Okay, so that's why they're going to try to say, oh, he was, it rose his suspicion that he was at this vantage point. But let me go back real quick to the other picture, the overhead view. If we look here again at this picture, I'm going to zoom in here a little bit. Okay, you've got the side door over here and the front door over here. That means anybody parked from here, all through here, all through here, all through here, and all through here would pretty much have the same vantage point of being able to see one door and see people approaching the other door. Okay? So from here all the way around to here, That's almost a third of the entire parking lot. It's a huge portion over here. So to say that somebody had that vantage point, that's not really particularized anyway, either, because anybody parked like that would have the exact same vantage point. So I'm not exactly sure why that would raise suspicion. So they're also going to talk about, oh, well, since he was asleep in his car and had the motor running, he could have been drunk, or he could have needed medical attention, or he could have been on drugs, and he could have been a danger to himself or others. So therefore, the community caretaking exception to the Fourth Amendment applies, and we could just forget about the Constitution and go ahead and do this, because we're not doing investigation into a criminal matter. We're doing our community caretaking. We're making sure that everybody's okay, which is bullshit. They were doing an investigation. They said repeatedly, we're doing an investigation. One cop even said, well, right now we're investigating your credentials. They also are going to admit that they ran the guy's his license plate, and it was valid. So, and by running his driver's license or his license plate, they knew who he was. So now when you get detained, now New Jersey is not a stop and ID state. Let me make that perfectly clear. New Jersey is not a stop and ID state. That means even if the cops have reasonable suspicion of a crime, that gives them the right to investigate, but that does not give them the right to take your ID. Okay? He didn't even have to say who he was. But altogether, he made there was 4 different means that he identified himself with. Number 1 was the car registration. It came back to his name, Daniel Madsen. 2, he showed his United States passport, which is the highest and best identification that you can hold in the United States. And he showed that to him, held it up to the window. Okay, these guys ran his name. They were looking for something, warrants or anything on him, but they couldn't find anything. So then they go to, a passport isn't a driver's license. Well, the cops you're going to hear in the hearing admit that there was no vehicular violation at all. No vehicular violation. So this was not a traffic stop. And since this was not a traffic stop and they did not have probable cause like cops have in a traffic stop. If you get stopped by a cop, that's not reasonable suspicion. That's called probable cause, because the cop saw you speeding. He saw you run a red light. He saw that your registration wasn't valid. He saw that your taillight was broken. Okay, that's probable cause. When you get stopped for that, you're required to give them your driver's license in most states. There's at least one state that says you've got to display or show them your driver's license. It doesn't specifically say you've got to hand it over. But so he then went and found his driver's license and showed them that too. And again, that was not good enough for the cops. Okay? The cops said, no, at this point, you got to step out. Okay, why? Obviously, this was not for officer safety, right? They don't even try to claim that this was for officer safety. Because if it was for officer safety, why would they let him root around in his car, right? Why would they let him go through stuff to go put his shirt on? Why would they let him go through stuff to look for his driver's license, okay? They weren't worried about him pulling out a weapon. Otherwise, they would have never let him do that, okay? So there was no officer safety involved. Okay. And let me tell you, as soon as people, because here's what everybody said on this video. Oh, Pennsylvania versus Mims. Pennsylvania versus Mims. No, Pennsylvania versus Mims does not apply because this was not a vehicular stop. There was no probable cause. If they had probable cause, yes, he would have to step out of his car. But since they claim that they had reasonable suspicion, which I don't even think they had reasonable suspicion. I challenge that wholeheartedly. But since they only had reasonable suspicion, he's not required to step out of his car. And he wasn't required to identify himself. But 4 different ways of identifying, they ran his tag, they knew who he was. But they're going to say, well, we can't verify their identification until we can have it in our hands. Okay? You're going to hear the defense attorney ask them, well, did you have any reason to suspect that his driver's license was suspended? No, they didn't. But they'll go, well, we don't know. I don't know. Well, you called it in, okay? You called it in, so of course you knew. Of course you knew you didn't have anything. So they just wanted to get in there, okay? As far as they're concerned, they had a homeless guy, and he was not respecting their authority. Respect my authority! And no, he wasn't doing that. And that pisses a cop off. So this is what it was all about. It was, how dare you disrespect our authority and not do whatever it is we say that you should do. And what he was doing is he was standing on his Fourth Amendment right to be secure in his person, in his papers, in his effects, and his home. Because, let's be frank here, he was living in his car. This is his home, albeit it's a mobile because he could drive away. So yes, you've got a, quote, reduced expectation of privacy. Still, if a cop comes up to your door and they only have reasonable suspicion, they can't force you to open the door. They can't bust down your door because they don't have a warrant and they don't have probable cause. So put that situation in the same kind of situation here. They didn't have probable cause. Okay? Now, he answered all their questions. When they asked him what he was doing there, he said he was sleeping. Okay? They had a conversation with him. So they knew this guy wasn't drunk. He wasn't high on drugs. I mean, he wasn't. They never said he had bloodshot eyes. They never said he was slurring his words. They never said anything. Now, if it was community caretaking and they're all worried about his well-being or the well-being of others, how come they didn't call an ambulance? How come they never took him to a hospital? How come they never checked him out? Because they didn't care. That wasn't what they were there for. You know, he also offered to leave because, you know, that's all they were going to have him do. They were going to shake him down. They were going to, you know, cuff him, go through his shit, and then kick him on his way. Okay? Well, they could have just let him go on his way, but no, because you're not doing what we tell you to do. So, all right, before we go on to this next audio of the hearing, let me take a look here and see what we're saying here in the chat. Slaves don't have rights. Yeah, that's correct. Yes, they repeatedly, you even see in the video. Nick Power, there is a link in the description to the original video if you missed the beginning of the broadcast here, and you can look at that. Yeah. Hey, Zoom Truth, good to see you, buddy. I got to talk to you soon, man. This is my good friend Zoom Truth here in the room. This is another guy that I did a video on, and we're going to be doing a follow-up. This is about the Point Pleasant Boardwalk, where he was filming the cops and got a ticket for illegally filming without a permit. Yes. So there is more to that story, too, that will be coming up. And but right now, let's go ahead and we're going to go on to the... Oh, well, okay, just before we do the video, let me show you what this guy got charged with, okay, because that's important too. He got charged with 4 items here, and let's bring him up here. First one here, he got charged with maintaining a nuisance. Now, this one is a local city ordinance, and it basically says if you upset anybody for any reason whatsoever, you're guilty of this crime. So in looking into this, this is a grossly unconstitutional law. We will be challenging this law in court because this is so vague. This law is so vague that they could charge you against this law for doing all sorts of things that are constitutionally protected activity. One example would be a street preacher, okay? A street preacher may annoy people and, quote, disturb their peace, but it's their constitutional right to stand out on a public street corner and preach, okay? But under this law, they would be breaking the law. Not going to go into too many more. There's a whole bunch of different reasons why this is void for vagueness and why it would cover constitutionally protected activity. The next thing he charged him with, of course, is obstruction of justice. And basically what they're saying is, oh, well, he refused to open his door, so he obstructed our justice, okay? Our investigation. He was obstructing it, okay? Well, there's one little problem with obstruction of justice, and you know, the thing is that it requires an affirmative action. It's not obstruction of justice to refuse to unlock your door, okay? It would be obstruction of justice if you ran over and shut a door and locked it, okay? Because that would be an affirmative action, okay? But by refusing to do something, he was not obstructing justice. Now, one way that I can help prove this is there is a court case, and it's actually a New Jersey court case. So it is absolutely applies under this circumstance. Now, this case, the State versus Fede, they charged same thing. They charged this guy with obstruction of justice, right? Okay, right here. He's appealing his conviction for obstruction of justice. All right. Now, what happened was somebody called 911 and said that there was a dispute, a domestic dispute, involving a male and a female at another apartment. Okay. They knocked on the door, and the defendant opened the door, but he had one of those little chain locks, right? You know, the little chain locks so it allows you to open your door just a couple of inches, right? So he opened the door with the little chain lock there, and the cops said they wanted to come in and look through his home to search to see if there was somebody that needed assistance, okay? So said the defendant refused in an angry, uncooperative, and hostile manner. You know, basically said, fuck you, you need to get a warrant, right? Told him the police needed to get a warrant. Said the woman's not here, okay? Well, the cops busted down the door. They searched through the apartment. They found no woman. Nobody else was there. And then they arrested this guy for obstruction of justice, for refusing to unlock his chain. Sound familiar? Just like this case. This guy refused to unlock his door, roll down his window, because he knew the police wanted to get in there and they wanted to search his car. And they knew that they just wanted to put him in handcuffs, rough him up, which they did. Okay? Now, this had to go up to the Supreme Court, the state of New Jersey, and they basically ruled that it is not a crime to refuse to unchain the door for the police to conduct a warrantless search. Okay? And they basically said that it's not obstruction of justice because it was not an affirmative action. That requires an affirmative action in order for it to be obstruction of justice, right? Okay. So then let's go to the next one here real quick. The next one that they charged him with 4 different offenses. 4. Okay. Disorderly conduct. So they charged him next with disorderly conduct, which is, this is your regular contempt of cop charge, right? This is what they charge you with when they can't get you for anything else. You're not cooperating or you're not doing what we say, that's your disorderly conduct, right? Okay, well, the problem is the charge that they charged him with here basically accused him of tumultuous behavior, okay? Well, you just saw the video. Was he tumultuous? No, no, he wasn't fighting. He wasn't arguing. He was calm. He never yelled. He didn't do anything to bring attention to himself. He put his shirt on when they told him to put his shirt on, put his pants on when they told him to put his pants on, showed him his driver's license when they asked to see his driver's license. When they asked him what he was doing, he said he was sleeping. Okay. The only things that he would not do is open the car door. Okay. And according to him, and is in order to make money, this guy sells CDs. All right. So he had a whole bunch of CDs in his car that he sells. He burns them and sells them to make money rather than panhandling or something like that. So I mean, I'll give the guy this. At least he's working to make his money to support himself, right? So, but since he was homeless and such, he didn't, and he got cash when he sold these CDs. He didn't have a bank account. So all his money was there in the car. And he was basically afraid that these cops were going to steal his money, that they were going to search his car and they were going to steal his money. And then when he went back and looked and goes, "Where's my money?" They were going to go, "What money? We don't know what you're talking about. There was no money there." This was his fear. So this is why, if you want to know why he didn't let them in, this is it. He was afraid that these cops were actually going to rob him. He's had some, being homeless, he's had some issues with the police before, but they'd always been calm. And so he'd always shown them his ID and talked to them and everything like that. But this guy came very aggressive, just banging on his window and trying to open his door and demanding that he open his door and get out. I mean, he said all of a sudden, though, once he turned on the video, all of a sudden the guy's demeanor changed, and then all of a sudden he stopped yelling. So disorderly conduct, he certainly is not guilty of that. Okay. Then the final one is hindering apprehension. So it's basically, they were saying is he was under arrest, even though they never told him he was under arrest before they broke his window. If they would have said, "Hey, you're under arrest, you got to step out of the vehicle," he'd have stepped out of the vehicle, because then they have a right to demand that you get out of the vehicle. If they're actually claiming that they have probable cause to arrest him, then he's got to get out of the vehicle. That's perfectly reasonable. So hindering, they're saying, is because he had the locked door, that was an obstruction to his arrest. Now, the problem with this, with hindering, is the same problem they've got with obstruction of justice. This requires an affirmative action, which means he has to place an obstacle in front of the police, or he has to create an impediment to him getting arrested, right? They can't just go, "Oh, you didn't unlock the door, that's hindering apprehension." No, that's not how the law is written. So in none of these cases do these laws actually apply to anything that he did. Yet here it is a year and a half later, and they are still prosecuting this guy. So let's now go ahead and move on, and let's go ahead and play the audio of his court hearing, okay? So you can hear exactly what happened in front of the judge. And here is Officer Smith, who is the one that you hear in the video for the most part. He's the one that was doing all the talking, and he will be on the witness stand as well as this security guard. Now, before we play this, I'll let you know that according to Daniel Madsen, the security guard never came up to his car. He says that it was Officer Smith here, or Corporal Smith. Corporal Smith came up to his car the first time and asked him what he was doing, and that, he said, "Oh, I'm sleeping." And "What are you doing at the DP&P? And what's that?" "Oh, DIFUS." "Oh, ha ha ha." And he laughed, like, because he had nothing to do with DIFUS. So what they're going to say, though, is they're going to say the security guard was the one that came up at first. And the reason why this is important is because they're using the security guard to create their reasonable suspicion, okay? They're going to say because this security guard used to be a state police officer. So what basically happened here is they realized that they were in trouble. You know, they didn't find anything in his car. They didn't find any drugs. They didn't know what to do because they didn't have him on anything really. So they didn't really have a reason to order him out of the car. So they needed to create some sort of reasonable suspicion of a crime. And that's why they're going to use the security guard. Because if it was just the cop that came up and did this and then came back a second time 20 minutes later after talking to the DYFS workers, then all you'd have is his suspicions. And he wouldn't have anything, okay? Because he got the answers that he was looking for. The guy was sleeping. He didn't know what the DYFS building was. So he had no idea that he was in the parking lot that the DYFS office also had, right? Crazy. So, you know, they basically should have just let him go at that point. They'd run his registration. They knew who he was. They knew he didn't have any warrants, okay? But their ego wouldn't let it go. Their ego. There's nothing worse than a cop's ego, okay? They just can't let any perceived disrespect go, all right? So let's go ahead and listen to this court hearing. It's about 20 minutes long. So here we go.
All right, Mr. Prosecutor, Mr. Farino, this is the Madsen matter. So, Mr. Prosecutor and Mr. Farino, was my understanding from previous discussions, not the least of which are most recently having been on August the 6th, that there was to be a trial in this matter. Mr. Farino has indicated today that rather than have a full-blown trial, he's interested in having a hearing as to probable cause on these matters. So has he had the opportunity to discuss that with you, Mr. Prosecutor?
Good afternoon, Your Honor. Charles E. Carroll, on behalf of the state of New Jersey. Yes, he did, Judge.
So, I guess this has been sort of a case where we've had starts and stops and starts and stops, right? Mr. Farino, you've not been on this case very long. Is that correct? Even though the cases are not particularly new.
I ordered discovery on June 22, so
Yeah.
that's approximately when I got the case.
Yeah. So, because I know back in April, I think Mr. Madsen indicated that he was, quote, rejecting the services of the public defender. So that's why you're kind of getting into this a little later. Ordinarily, I might have expressed some degree of frustration as to the fact that for a case that's over a year old, we're just now talking about probable cause. But given the fact that you weren't on the case from its inception, I'll assume that that's the reason why we're just having that discussion now. So, gentlemen, what, if anything, would we like to discuss before we commence the hearing limited to issues related to probable cause? Are we stipulating to anything? Are we agreeing to anything? Are we setting any sort of ground rules before we start?
Not on my own.
I don't think I think it'll be brief anyway.
It sounds like it ought to be. Mr. Farino will then make a determination, I assume, based upon my finding as to probable cause, as to whether you wish, if I rule against you, to proceed today with a full trial. I'm assuming the state is prepared to proceed with a full trial. You've got at least a couple of witnesses here. Or if you wish to take some other recourse, right? Mr. Farino, we can have that discussion if it becomes necessary, right? Okay. All right. So, for the record, this is WT 2796, 2797, 2798, and 2799. It alleges a local ordinance violation of maintaining a nuisance. It alleges obstruction in violation of 2C29-1A. It alleges disorderly conduct, 2C33-2A, and alleges hindering in violation of 2C29-3B. These charges purportedly stem from an event that occurred on March the 20th of 2018. These charges predate me. I note that your first appearance, Mr. Mattson, was done by Judge Palmer, because that's his signature on the back of the tickets. But you and I had subsequent discussions where I did subsequently advise you of your rights, not the least of which being your right to be represented by the public defender, because you filled out the application and I reviewed it with you, correct? Do you need me to review any of that with you again at this point, sir, or have you got it both between my discussion with you and Judge Palmer's previous discussion with you? Okay, that and the fact that you're also represented by counsel. So, all right, that takes care of that then. So, Mr. Prosecutor, Mr. Farino, as I understand it, the state can present testimony upon which this court can determine whether or not there rests probable cause to proceed with the charges, correct? And I'm assuming that is your intention. How many witnesses do you intend to offer?
I anticipate calling 2.
Okay. Mr. Farino or Mr. Prosecutor, are we going to sequester the witnesses?
That was my intention, Judge.
Okay, so why don't we, who are we going to go with first?
Judge, Charlie Maxamillionaire is in the back of the courtroom. That would be the state's first witness.
Okay, come on up, sir. Mr. Mattson, any questions before we start? You good? Okay. Come on up, sir. Up here, please. Thank you. Just make some notes here. Probable cause. Here. All right. Sir, you are Charlie Makatura, Makatura. Is that right, sir?
Correct.
All right. Mr. Makatura, sir, you swear the testimony you're about to give me the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. Mr. Prosecutor, all yours.
Thank you. Mr. Makatura, by whom are you employed?
Presently with Allied Universal Security Services.
And how long have you been employed by Allied?
4.5 years.
And as part of your employment with Allied, do you have any connection with the Department of Children and Family Services?
Correct. My present assignment is with Division of Child and Family Services. They're located at 415 East Washington Street, Washington, New Jersey.
And were you working on the morning of March 20th, 2018?
Yes, it was.
And on that occasion, on that date, did you have reason to reach out to the local police department?
Yes, I did.
And can you explain what prompted you to reach out to the police?
It's approximately 10:30 in the morning. One of our division of, I call them DIFUS workers, came in and notified me that he had observed a vehicle out in the parking lot from 6 a.m. And when he returned at approximately 10:30 a.m., this particular vehicle was still in the parking lot with the engine running, and it wasn't one of our vehicles. So at that point in time, my office is located right in the very front of the building. I walked outside. We have, in that particular location of the parking lot, there's several rows that we park the state vehicles. Predominantly, most of them are Caravans. This particular vehicle was parked in the third row.
Oh, sorry about that.
Facing the building in between other vehicles, such as the Caravans. Now, they're not all Caravans, there are various vehicles there. But it was parked in such a way that obviously it arose my suspicion
because the parking lot is quite large. So everything in front of the building was vacant. Well, especially would have been at that time of day, 10:30 in the morning. There's not a lot of cars in front of the building. Most of the employees park on the side, and that's where this particular vehicle was. So, you want me to continue? Okay. Anyway, I made contact with the vehicle. It was, I have in my notes here, silver Dodge Caravan. It had Michigan registration on it, which obviously was out of character to be parked there. But the thing that was a little bit more heightened my awareness is the vantage point of this particular vehicle is parked in such a way that you can not only see the side door that our employees use all the time, but you can also see the front door, or at least not necessarily the door, but anybody approaching the front door. So it was kind of a strategic vantage point. Again, based on my experience, my background is in law enforcement, I'm retired state police. To me, it was a miss. It didn't make sense. The problem that we have at Division of Youth and Family Services is a lot of our workers have basically threats against them. It's not uncommon for somebody to be disgruntled. It wouldn't be uncommon for somebody maybe to stalk one of our employees. Also, what we have, it's not uncommon for, we may have a domestic situation where, one of the partners may wait knowing that the other partner is going to show up at our office for a meeting. So there's a lot of times we're always on guard, on vigilant for somebody that maybe want to come in. I mean, the whole purpose of being there for armed security is to protect not only the civilians and the clients that we have, but obviously our employees. This definitely rose to the level of suspicious. Just the way just in the mere nature of the way it's parking. Anyway, I made contact with the defendant. He was in the back of the car. The engine was running. He was covered with a blanket. As he came up to speak to me in the driver's side window, I noticed he had no shirt on. He only rolled down the window approximately an inch or so. Understanding my position, I'm no longer a sworn officer. I think I asked him, "Are you all right?" Again, the exact conversation. Unfortunately, I didn't document it. But it would have been in the nature of, "You all right? And what was your business here?" If I'm not mistaken, the defendant explained that they were there waiting, or he was waiting for Division of Motor Vehicle to open up. Again, based on just the mere nature of the appearance, the vantage point, the out-of-state plates, and what our sole responsibility is, I realized I couldn't go any farther with the investigation with my limited powers. I went inside and notified the Washington Police Department. If I'm not mistaken, now, in many occasions when I call the police department, sometimes I call the direct line, sometimes I call 911. This particular case, I think, and I'm not sure, I called 911. Suspicious person, and let the police officers come out and ascertain why this individual is there.
Okay, I'm going to pause that for just a second. So, first of all, he didn't call 911, okay? He says he thinks he called 911, but we've contacted them, and we did open records requests, and they now say that he did not call 911. He called directly to the police station itself. So the only audio that we've got of any kind of complaint is the audio that the person from the police station then had to call dispatch to have dispatch send out some officers. So there's no record at all of what he said. I love how cops do this. Cops do this all the time. I've got a suspicious person, yet they never say suspicious of what? Suspicious of what crime? Now he's implying that somehow him being asleep in the back of a parked car with no clothes on, underneath a blanket, with curtains in the back of the van, somehow is indicative that he's about to come attack somebody at the DIFAS office or the Family Services office. Now, I don't know what world you're living in that makes you think that a homeless person sleeping in the back of his car in a parking lot, somehow it's reasonable to suspect that they're about to commit a violent crime on people inside that building. I mean, that's just beyond fathomable to me. But let's continue.
And on the morning of March 20th, 2018, which is obviously some time ago, did you have that knowledge of threats to employees that you testified about a moment ago?
We are constantly being given updates of individuals, and what they'll do is, I mean, if it's a known individual, we have a drawer and top with, we keep photographs. But it's not uncommon for them to have, again, they'll come out and say so-and-so has a threat, or it's not uncommon. It seems to be like a normal practice that we're always vigilant for somebody.
And are there children that come in and out of the building?
Correct.
On a day-to-day basis?
A lot of times, especially on that particular side of the building, there's 3 particular rooms, and they all, from that, where that vehicle was parked, they had a perfect vantage point of looking in those windows. That's the visitation rooms that we use for the children. Again, it's not uncommon for a client to come in with a DYFS worker to have a visitation with children, and at the same time, maybe have the other partner come in. Maybe there's a domestic violence restraining order. There's instances where we have to take people out the back door because we can't have them both in the same building at the same time. But again, it's on that side of the building, facing that parking lot, and your vantage point is looking right into those windows.
So there we go. Now it's the safety of the children now. Now, for some reason, sleeping in your car, now it's reasonable to suspect that you're going to either attack a partner or, I don't know what, do something to the children. But the children.
So if they're illuminated and the lights are on, they're not two-way glass. I mean, you can see outside, and if you're outside, you can see inside.
So I don't have anything further for director.
Okay. Mr. Perino?
As Mr. Makatura, you say you've been at your job for about approximately 4 years.
December 6th, 2014.
All at the same facility that's in question
Correct.
right now. And
Only at that facility.
so obviously you're familiar with the parking lot, correct?
Correct.
Are there any parking restrictions in that parking lot?
To the best of my knowledge, no. I know that there used to be a large sign, and it may still be there. They don't want overnight tractor trailers parking, but it is a private parking lot.
Well, you say private, it's not really private.
It's private. It's private land. Privately owned.
It is open to the public.
It's quasi-public, correct.
You say it was parked between some other vehicles. So is it fair to say it was still legally parked? There was nothing illegal about it, was there?
As far as no.
And would you confirm that there's no signs of any sort restricting parking in any way or time?
I would say it's probably accurate. To the best of my knowledge, that's an accurate statement.
No signs that say no parking overnight?
No, not that I know, no. Again, I think, there used to be a large sign for tractor trailers, no parking overnight, because they had issues with that. But I don't think there's anything that would stipulate that.
Is there anything that says customer parking only or only for
No.
official business? Did you say you approached the vehicle?
Correct.
Did you meet with Mr. Madsen
I
at
did
all?
speak with the defendant, yes.
as you spoke with him, did you see him do anything illegal?
No,
Did he ever get out of the car?
no,
So your only vision of him was within the vehicle.
correct.
And you say he did not have a shirt on. Do you know is there anything illegal about not having a shirt?
No, sir. However, it was out of the ordinary that you would not have a shirt on, but at the same time have the vehicle running for heat and be covered in a blanket. But is it illegal?
Did you have any reasonable suspicion that he had done anything wrong?
No.
Weren't all your concerns based on the future, that maybe someone could do something wrong?
Based on my past experience and expertise, absolutely.
But this
Heightened caution.
This individual did absolutely nothing wrong.
No.
That's all the questions I have.
So there you got. This security guard is now admitting, okay? He's admitting that he had no probable cause, that it was perfectly legal to park there. There was no signs prohibiting overnight parking or anything like that. You can see by these pictures that I've been showing you. Okay, this is the whole front of this little strip mall. Now they're trying to make it sound like he was just in the parking lot of the Division of Family Services, a state agency. But as you can clearly see, it's a strip mall. It's only one office out of like 4 or 5 different commercial locations there. There it is, called the Warren Plaza. Okay. So they got the Dollar Tree, they got the Division of Family Services, and they got a couple of, I think one of them's a pet store or something like that. This is a little bit of an older picture from Google Maps. But, at the time that he was there, they had like a pet store and something else in there as well. So, I mean, it was multiple little businesses. And again, like you can see in this picture again, there's the Dollar Tree. I mean, you can clearly read the Dollar Tree right from there. And then over there, Department of Children and Families. Okay, you can barely make that out. I mean, it's small, little teeny. I mean, look at the truck. Okay, the truck has bigger letters on the side of it than the Department of Children and Family Services. Okay, that's how hard it is to even know. So him coming in all the way on this left-hand side at night, he had no clue that he was in anything other than a regular parking lot here from a strip mall. See, here's the entrance where he would have come in. He would have been parked right back there from the left-hand side, the second row. Okay. The guy testified that he was about 50, 60 feet away from the office, but actually when you look at the overhead view, you can tell quite clearly that it's actually a lot farther than 50 or 60 feet. Okay. There we go. So there's the building. Zoom in a little bit here. There's the building. There's the front door. He was parked all the way over somewhere in here. He was like probably one of these 2 or 3 spaces right in here. Okay. And what are these for reference, these parking spaces, they're about 18 to 20 feet deep each. So, and then the width of this is even greater, the width of the driving lane. So you've got 2 driving lanes and 2 more parking areas. So realistically, you're looking at probably nearly 100 feet away, not 50 feet. So, I mean, if you were trying to surveil or something like that, I don't know. I would think you'd want to be closer to be able to see, maybe not. Who knows for sure. But, basically they're really stretching here. They're really stretching as to, how come we've got, why did we have to stop this guy? All right. So let's continue.
Any redirect?
Mr. Mokhtar, how far was it that you said he rolled the window down to speak to you?
Approximately an inch.
Did that concern you at all?
Absolutely. Again, based on my, training and experience, years on the road, it, basically it was deceptive behavior. In my opinion, it was a deceptive behavior.
Okay, I'm sorry. I got to stop that again, because this is real. This is what really got me. Rolling down his window only an inch was deceptive behavior. Deceptive how? How does that deceive you? I mean, he answered your question. You asked him what he was doing there. He said he was sleeping. So where's the deception? See, they're trying to take every tiny little thing that they can, and they're trying to build them all together. All these little wispy twigs of nothing. And they're trying to put them together and trying to show you how they've got a solid case of reasonable suspicion, okay? Because so far, as they've admitted, they have no probable cause. He admitted that he has not already committed a crime, and he admitted that he was not currently committing a crime. What he said is that he might possibly be planning to commit a crime in the future. So now we're dealing with future crime. And this is what cops love to use for their reasonable suspicion. A lot of times it's not reasonable suspicion that they have committed or are committing a crime. It's reasonable suspicion that, in the future they might commit a crime, which is the weakest suspicion of all. I mean, that's, in my opinion, that's the weakest suspicion of all. But let's continue.
Based on all, thousands of people I've probably dealt with in my career, that's not normal behavior. Realizing I'm not a sworn officer, but nevertheless I am in the uniform. You can tell that I'm there for professional reasons. I'm not out just trying to harass the public. In that setting, it definitely, erodes suspicion.
Okay, so basically what he's saying is that somebody homeless sleeping on a mattress under a blanket in the back of their van with curtains in the van is not normal. It's not normal. Does this guy not have a Walmart around him? Is he fucking insane? What do you mean not normal? Just go to a Walmart at 1 o'clock in the morning. Go to any Walmart across this country, and I will guarantee you that you will find people sleeping in their car. And if that's reasonable suspicion of a crime, that every single one of them can be yanked out of their car and thrown in handcuffs if they refuse to open the door just because the cop wants to talk to you. Bullshit.
Do you feel that you had an option not to call the police?
Absolutely not.
See, he had no option not to call the police. It was such a dire consequence, such a dire situation. It was imminent. There was imminent harm going to come if he didn't call the police to protect us now. That's where he's at. I had no option. I had to call the cops. There was just no way that this wasn't suspicious that he was going to come attack somebody.
Mr. Farino, you need to tell your client that this isn't a joke. These are serious proceedings. He needs to stop with the facial contortions. He needs to stop with the sound effects. Okay? Mr. Madsen?
Understood.
I'm giving you, the court staff is giving you their time to listen to these proceedings with an open mind, in a fair manner, and you're not helping yourself by the outbursts, either the facial contortions, all the noise. So just, let's all sit here, let's all listen respectfully, okay?
See, he's having a hard time sitting back and listening to this guy lie, okay? Because first of all, again, according to him, and I've asked him over and over, he says that he is absolutely certain that it was Corporal Smith that came and knocked on his window the first time around, as well as being the one who came back the second time. That this, he was saying, you couldn't hear the audio here because I've got to put on just the defense channel for you to be able to hear just what was coming from the defense microphone. But I played it and I put up the volume. You could hear him telling his lawyer, I've never seen this guy before in my life, because he wasn't there. He was there. He was over at the building 100 feet away, but he never approached his car. And he knows that this guy's lying. And it's frustrating as a defendant to be sitting there and realizing that the cops and the security guard are sitting there on the witness stand testifying. They're lying. And you know what? We supposedly live in a system where you're supposed to be innocent until proven guilty. But let me tell you what. If a cop says something happened and you said it didn't, you're guilty. You're guilty unless you can prove that that cop is lying. If you can't prove that cop's lying, you're guilty. That's the system we live in. That's the system the way it stands today. And it's wrong.
Judge, I have nothing further.
All right. Any recross? I just wanted to, just wanted to pick up on you just can't remember the exact words that Mr. Montefiore used. You were saying something like that. Based on your prior experience, you have seen many people similar to Mr. Madsen's behavior that day, such as out of the ordinary.
I've definitely encountered people that display the same type of demeanor and mannerisms, yes.
Did all of them that you've seen actually commit crimes as a result of their behavior?
Not all of them. Again, I'm not suggesting your client committed a crime at the point in time that I had engaged with him. I was just needed to know why he was there at that vantage point based on what I'm there for. My sole purpose is to protect not only
You
the
will
client.
admit in our society today, there's a lot of people that don't fit the strictly ordinary.
But again, not parked in that location, not with that vantage point. There was too many indicators not to rise suspicion, that wouldn't rise suspicion.
Too many indicators. Too many indicators. I mean, it baffles my mind. He answered the question to whoever the first person was came up. I'm sleeping. He answered it again in the video when the other officer asked him, what are you doing here? I'm sleeping. I mean, it's asked and answered. Hello? That should have dispelled. I mean, what part did you not get? I mean, there's curtains in the back of the van. He's clearly living out of his van. He's got a blanket and a mattress, and he's underneath there without his clothes on because he's sleeping. Who likes to sleep with their clothes on? Okay? I don't sleep with my clothes on. I know many people don't sleep with the clothes on. Now, not everybody sleeps in the buff, and it's questionable whether or not he had underwear on. Okay, that's an arguable point. He says he did. They said he didn't. Who knows? Doesn't matter. He was under a blanket. Okay? That's what people do when they're sleeping. Okay?
That's it. Done?
Yes, Judge.
Thank you, sir.
Thank you.
Your Honor, at this time, the state calls Corporal Phil Smith.
All right. Corporal, you swear the testimony you're about to give me the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
What's your badge number, sir?
25.
Thank you. Have a seat. All yours, Mr. Prosecutor.
Corporal, by whom are you employed?
Washington Township Police Department.
And by, how long have you been employed by the department?
This department, 16 years.
And were you on duty on the morning of March 20th, 2018?
Yes, sir.
And on that morning, did you have occasion to be at the DC P&P parking lot?
Yes.
And what led to your arriving at that location?
We received a call for a suspicious vehicle and male party inside the parking lot. Dispatch advised us that the caller stated they'd been there since at least 6 o'clock in the morning. Want us to check it out.
And were you able to locate the vehicle in question that morning?
Yes, sir.
And do you recall the make of the vehicle?
It was a Dodge Caravan, 2003 Dodge.
Okay. And where did you locate the vehicle?
It was approximately 50, 60 feet away from the DC P&P building. When I first approached the building, there was employees standing outside, and they flagged me down and pointed out that this specific vehicle was the vehicle that they were referring to.
And did you make any observations about the vehicle itself?
Yes, sir. It had Michigan license plates. There was some damage to the exterior of the vehicle, the front quarter panel of the vehicle. There was drapes across the rear portion of the windows, the rear side area of the vehicles on both sides. That's what I initially observed, sir.
Okay. And did there come a point where you approached the vehicle?
Yes.
And as you approached the vehicle, did you determine whether or not anyone was inside the vehicle?
Yes. I had noted that the vehicle was running. I approached and saw a male party who was sleeping in the back on a small mattress in the vehicle.
Is the individual you saw in the vehicle that day in the courtroom here is 7?
Yes, sir.
And where is he?
He's seated right in front of me as a defendant.
Okay. And did you have occasion to interact with him, to speak to the defendant?
Yes.
And what was the nature of that communication?
My first communication is when I approached and saw him, I knocked on the window, advised him of my name and department that I was employed by, and his initial reaction to me was he woke up and began laughing. I then advised him to, he was again laying down on back, advised him to obtain his credentials, identification, and step out and talk to me.
And did the defendant provide those credentials?
No, not at first.
And did you repeat your request?
Yeah, when all said and done, approximately 10 to 12 times throughout the entire duration of my being there, I asked him to provide his driver's license.
Did the defendant provide any identification documents to you?
After a short time, he located a passport and was showing it to me through the window. I again advised him to provide me with his driver's license. It was at that time I also noted an officer on the other side of the vehicle advised me that he had no clothes on. I saw that he had no shirt on, but he said that he was naked. So while he's looking for his initial documentation that he showed me through the window, I could also see that while he was moving the blankets around, he had no clothes on at all. A short time later, he then provided me with, he held up inside the vehicle a Michigan driver's license.
Did the defendant ever roll down his vehicle at your request?
No, he didn't.
Strike that. Did the defendant ever roll down his window at your request?
No, he did not.
And was his showing you that identification up against the window sufficient for you to be able to leave?
No, it was not.
And why is that?
For all I knew at that point, it wasn't a valid documentation. And then because of the reason for the call, I need to investigate further why he was there.
Okay, so basically he's saying he doesn't know if the documentation is real, so he needs to have it in his hands. And also, he needed to know why the guy was there. Like any normal person wouldn't realize he's sleeping. He's homeless and he's sleeping. I mean, what was holding his identification going to gain? First of all, it's not a traffic stop, so he's not required to hand over his driver's license. He wasn't required to even show him his driver's license or his passport. He did what he was required to do if they were already going to arrest him or write him a citation. And only in New Jersey, the law states that if they're going to write you a citation, you must provide your name and birth date. And he provided that both verbally, with his passport, with his driver's license, and they ran his registration. So 4 different ways. They knew who the hell he was. But they're saying, no. And the law in New Jersey does not require, under these circumstances, under reasonable suspicion even if they had reasonable suspicion, does not require that you hand over a driver's license. Many people don't have driver's licenses. Some people don't have ID at all. Obviously he did because he had a car and he was driving. He wasn't driving when he was stopped, but, obviously he had to get there somehow. But, so, I mean, if they were to come across somebody else in similar circumstances, not in a car, they couldn't require him to have a driver's license. And because this was not a traffic stop, they admit this is not a traffic stop. Since it's not a traffic stop, any requirement that he would have to ID would only be a verbal requirement. And he's saying, I don't know if his driver's license was real because I couldn't feel it. Because I couldn't feel it in my hand to see, even though I could call it in, and they did. They called it in. They called his information in. They looked. They knew they had no warrants or anything like that. That's not what this was about. This was about disrespecting their authority. They told him to do something, and he stood on his constitutional rights. It was his constitutional rights to be secure and not have them pull him out of his car and not have them search his car, which they did anyway. They broke his window. They searched all through his car, couldn't find anything, had it towed away, took him down to the police station, wrote him up 4 citations, and then kicked him loose 2 hours later. No hospital, no ambulance, no nothing. So they weren't worried about his safety or his health or anything like that. They were worried that he didn't follow their orders.
You indicated you've been with the force for a long time. When you come across an individual who's sleeping in a vehicle, what concerns do you have for that individual as part of the normal investigation?
Make sure that he's not impaired, whether it be through alcohol or some kind of illegal drugs. Make sure that he's going to be safe as well as the public before I just allow him to leave.
So on the morning of March 20th, would it be fair to say that you had concerns not only for the defendant in connection to DCP, but also for him as an individual?
Yes, sir.
Did you recall making any notes about the inspection sticker on the vehicle?
I could see that it was not in New Jersey. I wasn't familiar with that inspection sticker. It's not one I commonly see, Pennsylvania, New Jersey, things like that.
Smith, do you recall how long it was approximately that you were interacting with the defendant through the window?
It's approximately 25 minutes.
In
25 minutes. A 25-minute detention. In that time, they would have noticed if he had bloodshot, glassy eyes. They would have noticed if he was slurring his words. They would have noticed if he was incoherent because he was on drugs. They would have noticed all these things in 25 minutes. But instead, at the end of 25 minutes, because he wouldn't roll down his window, he wouldn't unlock his door, they broke his window, hauled him out, slapped cuffs on him, and took him away.
in your time with the department, have you become familiar with, strike that, in your time with the department, have you had to go on any prior calls to DCP&D?
Yes, sir.
And what were the nature of those calls?
Within that year's time frame of that individual call, we were called there for a total of 7 times, relating to everything from people threatening to blow up the building, kill employees, everything suspicious parties in general, threats against the lives of employees and families.
And you had that knowledge with you as part of your
Yes, sir.
interacting with the defendant on the morning of March 20th?
Yes, sir.
Now, realize, so he's saying the guy could have been there to blow up the building. He could have been there to attack and murder somebody, or this, quote, suspicious persons in general, which, again, is really a convenient thing where they say that they don't have any individualized suspicion because they can't say suspicion of what. Suspicion of what crime. You can't be a suspicious person without being suspicious that you have, are committing, or about to commit a crime. Now, cops seem to forget that part, that it suspicious of a crime, okay? Not just you're weird, you're odd, it's unusual, okay? Unusual is not reasonable suspicion. It's not reasonable suspicion of a crime, okay? So also, all of these things he's saying are relative to this area, to this building, right? At this building, they've had bomb threats. At this building, they've had threats of attacking people. At this building, they've had these things, okay? That's the equivalent of a, quote, high crime area. That's like saying, I found this person in a, quote, high crime area, so I detained them. I detained them to search to see if they were up to one of these crimes that happened in this high crime area. That's not individualized suspicion. Suspicion must be individualized to him. What made him suspicious that he was going to blow up the building? Was there a weapon? Did you see a gun? Did you see a bomb? Did he have a baseball bat? Is it normal for naked people to come and attack? Is that normal? For a naked person under a blanket to come out with an Uzi or a bomb and come and attack the building? I mean, where's the individualized suspicion to him? Continuing.
I believe it was 5 times prior to this incident we're discussing, and twice after, within, again, a year's time frame.
You indicated that the vehicle was running.
Yes, it was.
Were you able to actually see the key in the ignition?
I not where I was standing. I was on the driver's side, but the vehicle was running.
Just one moment, Judge. Judge, I don't have any further direct questions.
Okay.
Okay, so before we get into the cross-examination of this unquote witness. Let's recap real quick. What is the suspicion that this guy did? Okay, let's see. When somebody came up to him and woke him up and asked him what he was doing there, he said sleeping. He only rolled his window down an inch. So there's suspicion right there. He only rolled the window down an inch. What was another suspicion? Another suspicion was the car was running. Okay. Were you suspicious that he was a getaway driver? Because otherwise I'm confused. What does having the car running, what suspicion of what crime does that bring to your mind? I mean, if he was a getaway driver, wouldn't it be more suspicious if he was sitting in the driver's seat with the car running? And if he was surveilling the building, would he be laying down sleeping under a blanket on a mattress, or would he be up surveilling the building? I mean, so then they're also trying to put in suspicion there somehow that he had a Pennsylvania inspection sticker on the card, which, of course, again, they say that there was nothing illegal about that. So, again, I'm not sure what that adds to any kind of suspicion. So, as far as I can tell at this point, they've got nothing individualized. They're putting together these little crumbs that don't mean anything, and then making assumptions or conclusions that don't follow. Like rolling down your window an inch is somehow deceptive. Makes no sense. He didn't say anything about what he said. He said, "What are you doing here?" "I'm sleeping." How's that deceptive? I mean, deceptive would be, I don't know, man, I'm whatever, or I don't know, something else. But sleeping, how's that deceptive? I don't know. So they've got all these little crumbs together. Oh, that he was parked where he had a vantage point. That was another, okay? And that they've had threats at this building. So these are all the things so far that they are claiming are their reasonable suspicion. And then they're claiming community caretaking exception to the Constitution because he might have been drunk or on drugs. Now, I might buy that if he was slumped over his steering wheel with the car running. Okay, that's usually how they find drunk drivers, is somebody's passed out in the front seat behind the wheel with the car running. Maybe at a stop sign, maybe right on the side of the road, maybe in the middle of the street. That would be reasonable suspicion that somebody is in need of medical care. But underneath a blanket on a mattress in the back of your van, how is that suspicious that you're either drunk or on drugs? Makes no sense to me. All right, so let's listen to the public defender cross-examine this guy.
Reno?
Officer Smith, did you check the plates on the car to see whether they were legally registered in Michigan or not?
The plates were run. I don't know if I was the officer who called in. I was the officer who initially called out with that license plate in the vehicle.
But to the best of your knowledge, the plates were legal.
Valid, yes.
You know of any ordinance or statute or law or anything that would say that you can't sleep in the car?
No.
Would you say sleeping in the car is a wrongful act?
Wrongful? I don't believe it's wrongful. It's not normal, especially that location.
Again, sleeping in your car is not normal. What universe are you living in, Corporal Smith? Again, I'll say, don't you have a fucking Walmart in your area? Are you trying to say that out of the entire United States, your area is so unique that you don't have homeless living in your car like everywhere else across the country? Everywhere I've ever been, every place I've known, have homeless. And many of the homeless live in their cars or live in an old RV or something like that. But no, this, according to Corporal Smith, is unusual.
You know of any law or ordinance that says you can't look suspicious?
A law that you can't look suspicious, is that what you said?
forgive me.
No, there's no law that says you can't look suspicious, but it does raise certain flags.
You can't look suspicious, or you can look suspicious, but it raises suspicion. Oh, that's basically what he said.
You mentioned the car had drapes. Were they illegal?
No. It was parked.
Was there any indication that when you first approached the Mr. Madsen, was there any indication that there was something wrong with him?
He was sleeping in a DCP&P parking lot with the vehicle running.
And I mean, as far as his well-being, was there any indication?
That's one of the things I needed to speak to him about. It's abnormal, I guess is a word. So that's one of the things I need to further speak to him about, to make sure that everything's okay. Not only for him, but the public in general, the building, employees.
So he needed to speak to him about whether or not he was okay. Yet in the video you saw, they never asked him. They never asked him if he was okay. They never asked him if he had been drinking. They never asked him if he needed medical help. They never asked him any of this stuff. So this is all hindsight bullshit that they're pulling out after the fact, trying to make up an excuse as to why they stopped this guy. Now, also, if this is what they wanted to do, is allay their suspicion, they could have asked him questions and talked to him about it. But no, these cops, by order of the district attorney and by law, they don't have to talk through glass. That's what the cop said. By order of the district attorney and by law. Now, let me assure you, there is no law. There is no law that says that cops don't have to talk to you through glass if they only have reasonable suspicion and not probable cause, okay? And I am working on a public records request right now to see what this memo is that the district attorney that he's talking about, because the district attorney in the audio of the guy that broke the window later on, he says, get a hold of that thing from the district attorney so we can see what to charge him with. Basically what he was talking about is when they've lawfully pulled somebody over. You guys have seen these videos, right? Okay, you've seen the videos where somebody's lawfully pulled over because, I mean, it may be a bullshit excuse, but the cop says they ran a stop sign or they crossed over the white line or they were speeding or whatever they made up, okay? And then they're told to roll down their window or to open their door. Well, under Pennsylvania versus Mims, yes, you got to roll down the window if they, or because if you don't roll down the window, they can order you out of the car. So pretty much when people refuse to roll down the window, if it's a probable cause stop, not necessarily a DUI checkpoint, but a probable cause stop, then yes, you can get pulled out of the car under Pennsylvania versus Mims. But Pennsylvania versus Mims also says that there must be probable cause. This doesn't fall under reasonable suspicion. Okay? So they weren't trying to do any investigation. All they were trying to do is get him out of the car. We know that because after they got him out of the car, they didn't ask him anything. Not a damn thing. All they did is search through his car and take him down to the station. I've got video, too. I know this for a fact because not only do I have that cop's audio that goes on for another 19 minutes beyond what I played because it gets boring, so I'm not going to bore you with all that. But besides that, I've also got the video and audio of Daniel Madsen in the back of the police car all the way until they get to the police station. So I know I've heard and seen everything that happened since the end of that video when he got pulled out of that cop car, or pulled out of his car, I'm sorry, until he got to the police station. They never interrogated him. They never questioned him what he was doing there. They never asked him if he was physically okay. They never asked him if he was suffering from medical malady. They never checked him to see if he was drunk which he wasn't. He hadn't had anything to drink. He hadn't had anything, no drugs. There was nothing in the car. The guy wasn't doing anything but sleeping.
You said in the past you've had what I guess I could characterize as terroristic threats that are made at that facility.
Yes.
But did these terroristic threats, aren't they as a result of someone at the facility calling the police and say someone threatened to do something?
They come in, whether it be through.
But the threat was made. It was verbally made.
There was threats made, yes. But again,
was there any indication from who you spoke with that Mr. Madsen made any threats?
At that point, no. But again, that's part of the investigation.
Did you have any reasonable or articulable suspicion that the driver was unlicensed?
I was unable to verify that the driver's license that he was providing was.
Did you have any reason that the vehicle was not registered legally?
I ran the license plate and it came back valid.
And did you feel that the occupant of this vehicle violated any ordinance or law?
It was under investigation at that point, after speaking with him.
That's all I have, Your Honor.
Okay.
Corporal Smith, did the defendant's refusal to roll down the window increase your suspicion towards him?
Yes, it was. Yes, it did.
And why would that be?
Because I'm trying to gather more information to make a proper determination as to who he is, what he's doing there, things of that nature. And by him not rolling down his window and cooperating in a manner which typically a person would, throws up more flags as to the possibility of something being wrong.
Were you able to conclude your investigation through a closed window?
No.
Could you have just left the scene at that point?
No.
Judge, I don't have any further redirect.
See, here's the thing, and cops do this all the time. He said, basically by him maintaining his rights, that raised his suspicion. So I'm not sure not wanting to open up your window so that they can haul you out and search through your car, how that makes you suspicious of a crime. I don't know what crime that would make you suspicious of, so I don't know how that would be particularized, but that's what the cops trying to say is, when people refuse to give ID or they refuse to answer questions, they say, oh, well, that makes them more suspicious. No, that's them standing on their constitutional rights, goddammit. And standing on your constitutional rights is not a reason of suspicion, period.
Any recourse?
No, Your Honor.
Okay, thank you.
Thanks, sir.
Okay,
Your Honor, if I could just have one more.
of course.
Thank you.
Thank you, Your Honor.
This time, Your Honor, the state would rest with regard to the probable cause.
Okay.
Basically, what the Supreme Court has ruled is that standing on your constitutional rights cannot be converted into a crime. And that's exactly what's happened here. They converted his maintaining his Fourth Amendment rights, and they converted that into 4 crimes. 4 crimes against him. So, I mean, and this judge doesn't give a shit. You're going to hear here soon. This judge doesn't care. This judge is, these cops are credible, man. That's all there is to it. They're great, man. Yeah, here. Yeah, well, take a listen. Yes, this is a probable cause hearing, except for we're going to find out here in just a minute that it actually isn't a probable cause hearing. The attorney is about to waive probable cause, if you can believe it. Check this out.
All right. Mr. Perino, the state has indicated that they are done. So what, if anything, do you wish to offer?
I have nothing to add except the closing argument.
Okay. Go ahead.
Okay, I'm going to read from Kraus versus Delaware. I'm sure you're familiar with that case, so I'll read it. It's one of the holdings. Except where there is at least articulable and reasonable suspicion that a motorist is unlicensed, or that an automobile is not registered, or that either the vehicle or an occupant is otherwise subject to seizure for violation of law. Stopping an automobile and detaining the driver in order to check his driver's license and registration of the automobile are unreasonable under the Fourth Amendment. And I say that the facts of this case, all they have is a suspicion. The car was legally parked. The defendant did not commit any crimes. There was nothing to indicate, to use their words, an articulable or reasonable suspicion that any wrongdoing was done or about to be done.
Okay. Mr. Prosecutor?
Your Honor, there's 2 things at play here, Your Honor. The first would be a motor vehicle situation where you have a vehicle running with an individual sleeping in the back of it. So that in and of itself would give rise to the officer's community caretaking duty to check on the motorist to make sure, as alluded to by the testimony of Corporal Smith, that the motorist is okay. It could be intoxicated, they could have overdosed, they could have had some other medical issue in a car that's running. So that in and of itself gives them reason to interact with a motorist in those circumstances, here the defendant. On top of that, we have an independent situation, which is the security officer from DCPD going out, having a conversation and making certain observations with regard to the individual inside and the vehicle itself. Again, the defendant wasn't clothed, there was an out-of-state plate, his car was running, he was asleep in the back. In a parking lot, he was not there for purposes related to DCP&P. So that's going to then provoke that individual, it was a matter of his duty to call the police. The police have to then investigate that suspicious person complaint, which is what they did. They went up to the vehicle, tried to get identification from the individual inside, weren't able to get the window rolled down by the defendant to actually get a look at his actual identification that he provided. And as the corporal indicated during his testimony, the mere fact that the defendant, on top of the fact that he was sleeping in this parking lot and he had a running car and he wasn't clothed, he had an out-of-state plate, that was draped across the back of the vehicle, the fact that he wouldn't roll down the vehicle to allow the officer to investigate that identification or to have any further interaction with him only caused to provoke further suspicion in Corporal Smith, which plays into the allegation from the security officer of the DCPD. So under the circumstances, in either event, I would say that the corporal had more than a justifiable suspicion to interact with this defendant via either the suspicious person complaint that originated from the security services related to DCP&B, or as a community caretaking obligation for himself as an officer, if he had simply come across that individual in that parking lot unprovoked by any call. They saw him sleeping in the back of his car running. He would have had a duty as an officer to check on his well-being. And part of that would have included making sure that the individual wasn't having a medical event, wasn't intoxicated, or had an overdose. And he couldn't do that through a closed window.
Now, I love watch how they've used this word, justification for an interaction. Never once do you hear the judge, the prosecutor, or the police say justification for a detainment or a detention. And they detained him. Within the first minute of that video, he asked the cop, "Am I being detained?" And the guy said, "Yeah, you're being detained." And later on, several times it was reiterated to him, "You're not free to leave." "Yes, you're being detained." "No, you're not free to leave." I think it was 4 times. 4 times in that interaction they said he wasn't free to leave, he was being detained. Now, having justification for an interaction is one thing. Were they justified in coming up and talking to him and having interaction? Absolutely. There's justification for any interaction. A cop can walk up to anybody on the street and have an interaction. That's perfectly legal. But as I'm sorry, as the Supreme Court said in oh God, now I can't remember it. The famous court case for being detained. Oh my God. Does anybody know what I'm talking about? What's the 1960s case about being detained for probable cause? The most famous one of all. For some reason, it has escaped my brain. I cannot remember it. But basically, it's where they have to say you have to have reasonable suspicion. Okay? They even say in that court case that a citizen is in a consensual stop, that they have the right to ignore and walk, and leave. And there's nothing that cops can do about it. No, not Brown versus Texas. Not what's the most famous one that gave them, that said you can detain somebody for reasonable suspicion instead of probable cause. It's the one that everybody always quotes, and I'm embarrassed that I can't think of the name. It's not Miranda. Terry, thank you, Tri-State. Terry versus Ohio. In Terry versus Ohio, it says, of course, cops can come up and talk to anybody they want to. Okay, that's a consensual contact. Okay, if they were doing community caretaking, then that was a consensual contact with him. Okay, what they don't say here is that they had the right to detain him, and then going beyond that they had the right to pull him out of the car because he didn't want to unlock the door, that they had the right to break the window and pull him out and arrest him. That's the problem here. So now listen to what this judge has to say.
Okay. All right, so again, this is a probable cause hearing. This is not a guilt or innocence hearing. This is not a beyond the reasonable doubt standard of proof. It's reasonable and articulable suspicion, as you've indicated, Mr. Farino, a much reduced burden of proof. So the charges here are 4. Let me start with a couple of findings. I would concur that the police do have a community caretaking function when they are presented with a situation such as this, a vehicle running, somebody in the back of the vehicle, it's their function, it's their role to investigate, to make sure that the individual or individuals, as it may have been, in the vehicle are not suffering some medical condition or some other malady that would require intervention by first aid squad, police, or otherwise. In addition, as the prosecutor points out, there is the observation that was made by the on-site security officer who did attempt to interact with Mr. Madsen to, at best, very little avail, which heightened suspicion. We live in an environment, like it or not, where we're told constantly, if you see something, say something. It's drummed into our heads. So the mere act of engaging or attempting to engage Mr. Madsen and then attempting to investigate is, in my mind, wholly appropriate. So that's in and of itself not enough for the charges. So now let's talk about each of the individual charges.
See, he said they had reason to investigate. They had reason for the interaction. They had reason to talk to him. But they didn't say, what he didn't say is they had reason to detain him. He didn't say they had reason to arrest him or to break his window or to force him to answer questions. Because even if you're being detained, that doesn't mean that you have to answer the cops' investigative questions. And they can only hold you for a reasonable amount of time before they have to let you go, even if you don't identify yourself, because he wasn't required to identify himself. He did anyway. But you see in some of these other videos with people where they don't identify themselves and the cops detain them for a while and then they cut them loose without identifying themselves because they know that they're not allowed to detain them for longer than a short period of time to either dispel their suspicions or to come up with more evidence of reason that they're doing a crime. And instead, what they did is converted his refusal to cooperate, his right under the Fourth Amendment, they converted that into a crime. They now said, since you didn't cooperate with us, you're obstructing justice. Since you didn't unlock that door, you are hindering apprehension. And I don't know what reason they said disorderly conduct, because there was no fighting behavior. There was no tumultuous behavior. There was none of that. You can see on the video. And for those of you guys that came in late, I apologize. Because of my computer, I'm not able to turn on the DVR function and still have everything flow smoothly. It buffers too much. So when I'm done, it'll take a little while before it gets posted, but then you'll be able to go back and see this whole thing from the beginning. Which I would suggest you do. There's a lot of great information in here. I did public records requests that brought in other audio. I've got still even some more that hasn't even been played yet. But I'll be putting together a shortened version of video for general public consumption. This is laying out all the evidence right now for people. So, okay, let's finish up here.
So why don't we start with obstruction, 2C29-1, subsection A. A person commits an offense if he purposely obstructs, impairs, or perverts the administration of law or other governmental function, or prevents or attempts to prevent a public servant from lawfully performing an official function by means of flight, intimidation, force, violence, or physical interference or obstacle, or by means of any independently unlawful act. This section does not apply to a failure to perform a legal duty other than an official duty or any other means of avoiding compliance with law without affirmative interference with governmental functions. So,
Excuse me, Your Honor.
Yes.
Are you going to make a ruling on these charges?
no, I'm going to find whether there was probable cause for the charges. as I said, when I started, I'm not making a finding here beyond a reasonable doubt. I'm making a finding as to whether there's probable cause, because that's what you asked me to find. So, again, as I indicated, the burden of proof in these instances is greatly reduced. It's reasonable and articulable suspicion that the offense has occurred. So, a charge was written for...
I wasn't arguing probable cause for the particular...
Then why do we have a probable cause? Then why do we have a probable cause hearing? I'm now lost.
For the stop itself.
All right, well, then I'm done. I mean, there was community caretaking. I set aside the issue of the security officer, which I find to be highly credible, not the least of which his testimony was credible. It was given succinctly. It was given clearly. It was given without the benefit or the need for the use of notes. His background also speaks to his understanding and his heightened awareness. As a result, he contacted the police. The police responded to a 911 call, which indicated there was a suspicious vehicle. They attempted to approach the vehicle after having gotten the 911 call, which they, quite frankly, would have been a dereliction of duty had they not done so. In addition to the fact then, as they approached the vehicle, they find a vehicle that, I believe the word was unusual. The setting, the circumstances, the occupant, the situation was unusual. So as I just indicated a few moments ago, from a community caretaking standpoint, their attempt to interact with Mr. Madsen is totally appropriate and totally within their function, and again, would have been wrong had they not done so. Was that all you wanted me to find?
Yes, because I'd like to take an interlocutory appeal at the Superior Court.
Okay, so your issue that now because you told me you wanted to have a hearing as to probable cause. So, when you say that, probable cause, I thought it was a probable cause as to the entirety of the underlying charge. But your issue is limited to the one issue of whether or not it was appropriate and proper for the police to approach Mr. Madsen based upon the facts and circumstances. Is that correct?
Under the holding of Kraus versus Delaware, yes. That's
okay. And again, so let me draw a distinction then. I don't have the case in front of me, but even just based upon the small portion of the case which you read, talks about stopping a vehicle for certain alleged violations, right? Again, I'm finding that there was a community caretaking function here, which is an exemption from the other constitutional requirements to be met if there's a belief that a member of the public may be in some need of assistance. And I'm finding that the officers, when they were faced with the situation that presented them on the date in question and the location, exercising their community caretaking function, sought to investigate. And I'm finding that that was appropriate. So, if that's the limited issue upon which you wish to take an interlocutory appeal, then I needn't delve further today. Are you stipulating as to probable cause for the charges, assuming that the initial interaction was appropriate? Or do we need to do, because I don't want to have you go up on that issue and then have you come back here and we're going to have a probable cause on the charges themselves. Do you want me to go through with my findings on them as well?
No. My position is once there is probable cause, then we could get into each of these individual statutes, which are fact sensitive.
Okay.
And we could have a trial on that.
Okay. All right. So at this point, I am finding that there was certainly probable cause for the interaction. That's really the question that you've asked the court to make the determination on. There was probable cause for the interaction based upon the totality of the circumstances that the officers faced that day, including but not limited to the observations and report of the on-site security officer who himself has a law enforcement background. But I'm finding even separate and apart from that, there was probable cause for the interaction with the defendant under the community caretaking principle. All right? So, Now, you are indicating what? That you wish to take this up on interlocutory appeal on that limited issue, correct?
Yes.
Okay, so we're going to afford you the opportunity to do that. So I guess this case is going to be stayed pending the outcome of whatever that interlocutory appeal is, correct?
That should do it.
Okay, all right. Anything further then?
No, Your Honor, thank you.
All right, sir, thank you. Officers, thank you.
Okay, so basically the defense attorney's argument was that there was not justification, and he wasn't that great at saying what he was meaning, I believe, because what I think was trying to say is that there was not probable cause to detain Daniel Madsen, because this was a detention, but they kept referring to it as an interaction. And of course there's reasonable, I guess, I don't think there was reasonable suspicion of a crime for the interaction. That's why the judge went and added on, well, this is an exception to the Fourth Amendment, right? This is the community caretaking exception. Now, let me point out that the community caretaking exception has never been ruled in any court case that you are able to force them out of their home or their vehicle under community caretaking without more than just their suspicion, without anything to back it up, that somebody might be a danger to themselves or might need medical attention. Let alone the fact that, again, they didn't call an ambulance, they didn't take him to the hospital, they didn't investigate whether or not he was under the influence or anything. They did none of this. So here's where it stands, though. Basically, the lawyer was saying that he wants to do an interlocutory appeal on this decision, which is basically taking this hearing and this decision that this was all justified by the police and take it up to Superior Court and do an appeal to them, asking the same question, whether or not this whole thing was justified. All right. But, and the judge was fine with that. The judge, fine, go ahead. We'll stay everything until the interlocutory appeal is done. Because you can go up the chain with that appeal, and then if you lose, you come back and you have the trial. Okay, that's basically what they were saying. All right? But then the attorney changed his mind. Now the attorney is not doing an interlocutory appeal, because the attorney found out he wouldn't have to just file the appeal. First, he would have to file a request for leave to appeal and then file the appeal. And he actually admitted to Daniel Madsen that he didn't want to do the extra work. He didn't want to do the extra work of having to go and do a request for leave to appeal, which is bullshit. I mean, could you imagine a lawyer you were actually paying money saying, no, I'm not going to do this for you because it would mean extra work for me? But somehow it's okay for a public defender to say this. That's okay. Not okay for your paid attorney, because your paid attorney's got to do what you say. You're paying him. But here, wait a minute, he's getting paid too. The state's paying him. Oh, but they only pay him a set fee. So the less work he does, the better off he is. All right? So now this piece of shit defense lawyer, and I'm not exactly a piece of shit. Yes, you're right. He could have asked some more questions. He could have asked some better questions. There's some things like that. But, okay, at least he did ask some of these questions and clarified some of these issues that are going to be important down the road. So, and he is a private attorney. He's not just one of these full-time public defenders. Okay. He's got his private practice, and in a lot of states, regular attorneys are required to take so many cases. They get assigned them as public defenders. Okay, so he's a regular attorney that has to take these cases, and they're required to. They don't get a choice. Okay, so he's gonna go now to a trial on December 3rd. Okay, and it's gonna be with this same crappy judge. And if this judge appeared to be ready to find probable cause for all these charges. He was about to go down the road and say why he had probable cause for all these charges. So I have no doubt that this judge is going to have no problem finding this guy guilty. Okay. And I don't think that Daniel Madsen is going to get any kind of justice until he goes through the appeals process. And all of these convictions, I am convinced, will get overturned in the appeals process. So, but, this is the way a lot of these cases are. When you're at the low courts, they don't care about the Constitution. They don't care about your rights. All they care about is convicting you. Okay? And once, as far as they're concerned, hey, if there's some constitutional questions or other things, we'll leave that up to the appeals court to overturn me then. Because a lot of people don't have the money or the means or the time to go and file these appeals. Okay. So a lot of times their rulings just stand because, that's nobody goes any further. In this case, Daniel Madsen is planning on going further. We're planning on going through the appeals. The attorney's already agreed that he's going to write up the appeal. And then, of course, he'll get assigned a different attorney for the appeals. But that's, So, do you guys want me to show you and analyze these charges and why they're not valid? Do you want to go through that, or do you have any other questions that you'd like me to cover at this time? Or let me look through the comments here and see what we're talking about. The case can be possibly retried because of ineffective counsel, but that's a very high bar. Proving ineffective counsel is very difficult to do. It's not so easy. Okay, all right. Let's go ahead and look at these laws then. I've got them all here so that we can do just that. Okay. And I'll go over this local ordinance too. That's just absolutely ridiculous. But we will go over it here. Here we go. Let's go start with that. Chapter 90.4. Oops. Nope, that's not it. Oh, wait. I know where it is. Hang on 1 second. Okay, pull it up there. I saved it under my bookmark. So let me get that up here. And okay, let's start with disorderly conduct. Let's go ahead and start with that. And we make it so you guys can see the screen here. All right, this is the code which he got charged with under disorderly conduct. Okay, and he got charged with this first one here, 2C 33-2, disorderly conduct. Okay, improper behavior. And he got charged with A1. So a person is guilty of a petty disorderly persons offense if with purpose to cause public inconvenience, annoyance, or alarm, or recklessly creates the risk thereof, he engages in fighting or threatening or in violent or tumultuous behavior. Okay? So first of all, his purpose has to be to cause public inconvenience, annoyance, or alarm. Okay? So they have to prove intent, or that he recklessly created a risk of those things. Okay? So that's the other way they can do it. Okay? He didn't engage in fighting. He didn't engage in threatening. He didn't engage in any kind of violent behavior. That leaves tumultuous. Okay? So let's just for the fun of it, let's look up tumultuous. What does tumultuous mean? Because that's the only thing that's left, right? It must be tumultuous. Making a loud, confused noise, uproarious, excited, confused, or disorderly. Okay? Well, you guys saw the video. Was he any of those things? No. He was none of those things. He never raised his voice. He was never violent. He calmly spoke to them. There was no tumultuous behavior. So we know that he's not guilty of disorderly conduct. So that's the first one. Then let's go. Obstruction. All right, so the next one's obstruction. Okay. Now, obstruction, this is going to be both obstruction and hindering. I'm going to have the same point to make here. Okay, obstructing a governmental business. Oh, wait, this is the jury instructions. Okay, in order to commit obstruction, you have to prove that the defendant committed an act of intimidation, force, violent or physical interference, or an obstacle. So now they're gonna hang their hat on this was an obstacle, that he placed this obstacle in here, right? So the obstacle was the locked door or the rolled up window, right? There's the obstacle. Well, first of all, he didn't place it there. It was already there, okay? So, and when they looked at it, when you look at case law and stuff on this particular case, and you look at you're preventing a public servant from lawfully performing official function, and that committing the act the defendant did or attempt to obstruct, impair, or pervert the administration of law or of other government function. Now, of course, he didn't do anything. It requires an affirmative action in this case. He must affirmatively do something to obstruct, okay? Then the other assumption is that they had the right to do this. Like they had the right to demand that he place the driver's license in their hands. Well, they didn't even have a right to demand the driver's license, let alone the right to demand that he place it in their hands. So this one doesn't, this doesn't qualify. Now, the same thing with hindering. We'll go on to hindering here, because under hindering, it's the same issue. Under hindering, it requires it's hindering apprehension. So in other words, he stopped the police from arresting him, and that was hindering apprehension, okay? And in the same thing in hindering apprehension, if you read down, which we will hear in just a second, it will tell you that hindering requires an affirmative action. And let's see if I can find exactly where it says that. A person commits an offense if with purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment, does something. Okay. For you to find the defendant guilty, the state must prove each of these essential elements. One, that the defendant knew that he or she might be charged with an offense. Okay. maybe you could argue that he might have known, because the cop did say something to effect of, well, you're not going to get arrested now, but if you don't come out of the car, then you might be. Okay, so, all right, maybe he knew, possibly. All right. That the defendant acted with purpose to hinder his or her own detention, apprehension, investigation, prosecution, conviction, or punishment. Now, I'm sure what they're going to try to do is that he was hindering their investigation, although I don't know what they wanted to investigate inside of the car. I don't know why they needed him outside of the car in order to investigate, because if all they wanted to do was talk to him, they were talking to him the whole time. But listening to the other cop's audio, you could clearly hear everything that Daniel was saying, even through the window. So it wasn't a problem that they couldn't hear. They could hear just fine. Now it says here the person must commit an act knowing with respect to his circumstances that he's aware that their conduct of his nature, such circumstances exist, that he or she is aware of a high probability of their existence. A person knowingly with respect, is that it's practically certain that he's going to get arrested. The second element that the state must prove beyond reasonable doubt is that they suppressed by way of concealment or destruction evidence or tampering with a document. None of this applies to him. Prevented or obstructed by means of force or intimidation from performing an act which might aid in his or her discovery or apprehension or in the lodging of a charge against them. Okay? He didn't use any force or intimidation. Okay? So that doesn't count. He prevented or obstructed by means of force, intimidation, or deception a witness or informant from providing testimony. Well, nope, he didn't do that. He didn't have a witness, and he didn't intimidate them. Gave false information to a law enforcement officer in order to obstruct. Okay, well, he did. He showed him, had identified himself in 4 different ways. So, let's see. Trying to read through here real quick. Okay. So it basically says here that someone has to act purposefully with the respect to the intended circumstances that he's aware of the existence of such circumstances. It basically says that someone purposefully acts. In other words, if you look through Justia law, it tells you that this requires an affirmative action that stops them from being able to arrest him. And just like I talked about earlier in this broadcast, under state versus fede, the same guy, the same kind of circumstances where they said he was not guilty of obstruction because refusing to unlock or unchain his door was not an affirmative action. So this applies also to hindering apprehension. He did nothing affirmative to hinder apprehension. Okay? It requires an affirmative. Like, for example, if he ran inside of his house and he locked the door, that would be hindering because he did something affirmative. If he's, runs away, that would be an affirmative action. If, I don't know, I can't think of anything else, but it requires an affirmative action, and he did no affirmative actions. So let me go then to the final one, and this is the really, what I think is the worst law that they're charging him with of all. And this is just a local ordinance. Where is it? New Jersey. Here we go. Township of New Jersey. nuisances. They charged him with a nuisance, a public nuisance, which I'm not exactly sure what they're claiming he did to cause this nuisance, but check out what the crime says that they charged him with. They charged him with 90-4, subsection get C1. The making, continuing, or causing to be made or continued by a person of any loud, unnecessary, or unusual noise, or any noise which does or is likely to annoy, disturb, or endanger the comfort, repose, health, peace, or safety of others. Okay? Now, you saw the video. He didn't make any loud noises. He didn't make any unnecessary noises. He didn't make any unusual noises. So what they got? They've got any noise which does or is likely to disturb or endanger the comfort, repose, health, peace, or safety of others. So in other words, if you make a noise that is likely to annoy somebody, you're guilty of a crime. Now think of what those things could, what could that cover? Okay, that could cover a street preacher. A street preacher annoys people, right? Under this town ordinance, a street preacher would be guilty of violating this ordinance, okay? So basically this falls under the idea that in the United States, if a law is so vague that it could be applied to constitutionally protected activity, then it is void for vagueness. Okay? So that's the plan that I've got right now. Is we're writing up a motion to challenge the constitutionality of this ordinance, that it's void for vagueness. So we'll be making that up within the next couple weeks, and we'll be filing that, and we'll see how that goes. And that's something else that it has to be brought up. It has to be brought up either before or during trial if you're making a constitutional challenge of something, because if you don't, you lose your right to appeal that. Okay, you can't bring that up on appeal later on and bring it up if you never brought it up before. Okay, that's barred. It's not allowed. So we're going to be challenging that. I think likely if we file this motion, I think it's likely that the prosecutor, rather than have his town ordinance get found unconstitutional, will probably drop that charge and just leave the 3 remaining charges. Okay, that's my suspicion. He might actually try to defend it, but don't think so. So that's pretty much covers everything, where we're here to date. And does anybody have any questions or anything before we do our final sign off? I will check here in the comments real quick. Let's see. Let's see here. Snoring buckets. Sarah Tay, whose court date are you talking about that's on the 25th? What? Was I missing something there? Yes, you're right, Lil Rob, that local ordinances, I get they do not trump the Constitution, and they are the weakest of laws. That is certainly true. And a lot of times they don't get challenged because of the fact that the fines are so little that they very rarely ever go up the appeals court. So Well, I don't actually. This attorney is not. I wouldn't say he's trash. I mean, yeah, he could have asked some more questions, but he's actually, I was somewhat impressed that he asked the questions that he did ask. Um, I've seen lawyers do a lot worse in a probable cause hearing. Who was absolute trash was the public defender for Frontline Media. In his probable cause hearing, the public defender for Frontline Media didn't ask any challenging questions. In many cases, he didn't ask anything. He just let them put on their case and didn't object to anything, didn't do anything. He was a crappy, shitty attorney, and he was just a public attorney. So this guy is not just a public defender. He's also a private attorney. So he's smart, he's knowledgeable, and I think he's going to attack the right things in the trial. At least I hope he does. Fingers crossed. But I don't really think in this case that it really matters, because I think this judge is going to find him guilty no matter what. And I think it's going to have to go through the appeals process, which is fine, because I would love to see this community caretaking bullshit get challenged in an appeals court, because that's one of these things that has not been settled totally in courts, is the community caretaking doctrine. In this case, is far outside anything that any court has ever ruled that the community caretaking doctrine allows you to do. Because community caretaking allows certain things. I mean, yes, they could have come and checked on his well-being. Community caretaking allows cops to come in, like the guy's home where they reported that there was an argument between a man and a woman, and they need to come in and check to make sure there's not a dead woman lying back in the bedroom or something. That's community caretaking. That's okay. They can break that guy's door down and come in there and look. Now, what they can't do is they can't go and look in drawers. Okay? They can only look anywhere a person or a body might be, like a closet, under the bed, in the bathroom, in the shower. Okay? They can't open up drawers or cupboards or things like that. They can't search your home. Okay? That goes beyond what they're searching for under community caretaking. You can't do that. Okay? But these cops arrested him, and then they searched his car. And of course, they're going to say, well, that was incident to arrest, or that was our community caretaking because we were just inventorying the car before it gets towed, right? Of course, they do a quote unquote inventory, but they never write anything down. They never actually inventory the car. They just say they're doing it, but there's no list of the property and things like that. So actually, this guy was really lucky that they didn't steal his cash, and he was able to get all of his money back. So his biggest fear, luckily, was not realized, maybe possibly because by that time there was 5 different cops witnessing the cash and everything like that. So, unless they were all crooked, it wouldn't have been so easy to steal it. So that's yeah. Okay. Do public defenders ever win a case? I mean, they work for the state, so do they even want to win? Yeah. I mean, public defenders do win cases. I would say most of them, though, when you're dealing with public defenders, they usually only are there to negotiate plea deals. They want you to plead guilty, and so they'll negotiate a plea deal. That's usually what they do. And then if you don't do the plea deal, then they'll give you a half-assed attempt at a defense. And a lot of times I see them, they don't cross-examine witnesses very well, things like that. They kind of put on a halfway, kind of a half-assed defense. But that's basically, that's kind of what you get. it's kind of par for the course. So, um, well, guys, I'm going to go ahead and wrap this up. I thank you for sharing this with me. Like I said, for those of you who did not get to see the beginning, this will take a little while to. This will take a little while to post up so that you'll be able to see it, but then it'll come up and you'll be able to watch the whole thing from the beginning. So, guys, remember, you've got to know what your rights are so that you can stand up for your rights. Because if you don't, you'll end up losing your rights. Thanks for coming.